Have you just retained legal counsel, a lawyer, and you're wondering or getting anxious about whether you're starting to rub your lawyer off the wrong way? Well, then keep on watching, because in this video, as an experienced lawyer of over half a decade, I'm going to be talking to you about 3 trends that make for poor clients, in my experience. For those of you that are new to the channel, welcome. Give this video a big thumbs up, and don't forget to click on the subscribe button down below. At Graphene Business Law, we offer virtual business law services to entrepreneurs and business owners throughout the province of Ontario, Canada. And when it comes to our YouTube, we post free educational content every week. And I don't know any other law firm that does the same or has been doing for years like we have. Did I say my name? My name is Pam Matani, and I'm the owner and founder here at Graphene Business Law. Now, this video kind of, there are rules of professional conduct as to what lawyers can and cannot say about their clients. Obviously, I can't give any identifying information or things like that. And obviously, from a business perspective, not even illegal, I'm not going to sit here on a rampage that is negatively directed at my clients, because at the end of the day, we want more clients, not less. So, there's nothing. I'm not going to put up a photo of anybody and say don't do this, but definitely there are patterns of behavior, and this video certainly was well inspired, I'll say that. There are patterns of behavior that can make for a poor and unprofessional client. And just the other day I was telling my colleague who was trying so hard to acquiesce to an abusive client that that's not really something you need to do. You need to deliver professional, high quality, competent services, the best you can. And if clients sort of turn left, well, that's more on them than it is on us as practitioners. And I always try when a client starts going off the rails or exhibiting one of these behaviors I'm going to talk about. But overall, these are personal choices. All my clients are adult clients, so they're as responsible for their conduct as I am for mine. And with the caveat there that part of the reason I try is because, some clients have lawyers on speed dial. For some clients, working with a lawyer is the first time they've ever done it in their life, and it can have different, impacts on their mental health and things like that. So just being cautious of people's different backgrounds. I'm giving this intro to the video so that you don't think that any of these cases are like a one and done. You do this and a lawyer shuts their books. It is very high threshold behavior that usually would require a lawyer to just fire you as a client outright. That being said, let's talk about 3 behaviors that when I notice as a lawyer, as a business owner, I'm thinking, please don't be one of those. The first behavior I want to talk about has to do with communication style, okay? And there's a pattern where, and I'll give a background to it. So as my practice has evolved, and as the practice of many lawyers has evolved, there's something now in the marketplace called block fees or flat rates, okay? It helps both very sophisticated and less sophisticated clients, because the number they're looking at is the final number they're going to be facing, and in terms of charges. And on my end, it helps me budget my time. It helps me orient my priorities as well. It helps me manage my caseload and all those details that would go into an efficient practice anyways. I should need to know how to manage my time to begin with. But flat fees, help us do a little better job of that as lawyers. There are some clients that when they pay you a flat fee for one service, somewhere in their mind, and you always start by giving the benefit of the doubt, but as practitioners, I'm reminded of what my mentor he'd been practicing like 45 years a day. I entered foot in a law firm. He said every day in this practice, he was a very high level business practitioner, business law practitioner. He said every day in this practice, I'm reminded that there's a new way to commit fraud. Basically, on my end, every day I'm reminded that there's a new way for someone to take advantage. So there are these clients that will pay the one-time flat rate, and somehow in their mind, it is interpreted as a flat rate which entitles them to ownership of my schedule. Okay, so the flat rate is pertaining to a specific retainer at hand. I complete a high quality service for you. Of course, there's payment in exchange for that. I'm not allowed to do free work even if I wanted to. There's rules around that. But that's sort of the exchange. We are focusing on a task at hand. It doesn't entitle you to, I had a client within the first 48 hours of retaining me, and this is in recent months. Within the first 48 hours of retaining me, I think maybe 35 emails were sent. Now, come on. Think of most human contexts in which that would be appropriate. Within 48 hours of the first date, 35 emails are sent. Within 48 hours of meeting your neighbor, 35 emails are sent. It's generally weird and a high volume of communications. But when it comes to law especially, you might not bill your date. But my time, if I'm not billing for this client, it means I can't feed my family. Like, there's still a human being just behind the successful practitioner. I didn't get to be successful by letting people take advantage. So the time I'm spending responding to this client's emails is time that, first of all, out of 35 emails, how many do you think were useful? Think of the math on that as well. Do you think all 35 out of 35 were high quality, useful emails? No, maybe 2 were useful out of 35. But there's also expectations on me as a practitioner from the legal code of conduct and things like that I respond at a certain time, that I respond quickly enough, that I acknowledge client communication. So for all these 35 emails, I've got to sit there and spend time acknowledging them, responding to them, engaging with them in some capacity. And that capacity of the 35, at least 32, 33 are completely useless. This is a client that is taking advantage. They think because they have a practitioner on retainer that they now get a free pass at asking any and all questions they want and that they are entitled to an answer. And what especially reinforces the tone of taking advantage is when they start asking legal questions that have nothing to do with the matter for which they retained. That's an easy answer, it's out of scope, but it still uglies the relationship. Okay, you ask me once, but don't ask me 35 times something that's out of scope. Don't you know what the answer is going to be by now? So, listen, that pushing of the boundaries, pushing of the envelope is a quality I condone. That is one of my personal traits to success, if you will. I never took that no for an answer. But there's you have to know the setting you're in. If your doctor tells you to not do some crazy drug treatment, it's probably to save your life. So that's a case in which hearing no could be okay, maybe, right? So you have to know the setting in which you're operating. Whereas being told, no, you can't have an event in this day at this venue, maybe you try with another staff member. But again, the way that some clients communicate, and they show themselves very quickly because these guys come in with a plan in hand. Like somebody that's of this type of client is not going to wait for 3 months to show their colors. They sign, boom, questions. That is a kind of client that, again, think of somebody before, I don't judge you guys, so you better not be judging me. But before you form any judgments, thinking, she just wants to get paid for every minute. Wouldn't you be creeped the hell out if somebody you just met sends you 35 emails in 48 hours? It's, I can't think of any human context in which that's okay. So same goes for law. Be cautious of how you communicate with your lawyer, and if you're expecting someone to be respectful to you, try your best to be as respectful to them as possible. Legal practitioners are human beings, just as I know that you as clients are human beings. The second quality, or the second trait that sort of outs a client as they're going to be a poor client, they're going to be a hard time of a client. If somebody, there's a difference between, and this is financially driven, there's a difference between bargaining for fees or negotiating legal fees before you sign that retainer. And there's a difference between signing the retainer and then trying to get freebies and then trying to get nasty with it. Because you are showing disrespect after signature for my work as a lawyer, for my time, but also for yourself. I'm supposed to take you seriously as a client, and you sign documents you didn't mean to sign or you didn't agree with as regards, the fees and the time spent on a matter in the retainer document, for example. So I've put up a video on this channel before where I actually condone, it's a good idea. Try to negotiate your legal fees before you start. Ask for a discount. Why not? Okay. Ask for a freebie to be thrown at you. Why not? Life's hard. If you don't advocate for yourself, no one will. So try to get something. But when you sign that retainer to then go back and say, I was wondering if we could lower this. I was wondering if we could this and that. At that point, you are just disrespecting our relationship. You shouldn't have signed something you weren't agreeable to or agreeable with. And you are showing yourself very unprofessional. Again, in case you form judgments thinking, I know why she's saying this as a lawyer. She just wants to get paid all the time. Well, first of all, wouldn't you? But also, second, and perhaps more importantly, think of it in the context of human relationships. You sign a marriage contract and half an hour later you get an email saying, what if we could undo one thing? Or you're selling a house, you really need the money, you trust that this buyer intends what they put on paper, and everybody signs the agreement of purchase and sale, and then you get an email, the next day saying, you know what, the only way I'm really gonna let you swipe my card on this house sale is if you lower the price by $100,000. Wouldn't you feel trapped, cornered, disrespected? Same goes in this setting. There's a difference between negotiating fees in good faith, negotiating them up front, and there's a difference, trying to take advantage of somebody after negotiation. A lot of lawyers differ in the way they take payment, actually, and it's very unfortunate. Sometimes lawyers don't take payment until the job is done. I don't think that's protective of the lawyer at all, because what that does, it allows for the amount of advantage that can be taken by the client to skyrocket, because then the client's going to tell you, I either pay you nothing or you force the discount I'm asking for. You've already done the work, so your costs are sunk anyways. Take my deal or it's no deal. And that's just straight up abusive. So that is a red flag in clients as well. And again, they start to show themselves. It's once in a while it happens that a client waits until the very end. That client is yet more sophisticated than the client that starts talking about fees as soon as they've signed. But usually, again, they show themselves because as human beings, they have anxiety too. They want to know that they're going to get the deal. They're going to get this other thing they asked for. So most of these patterns of behavior, the clients show themselves sooner than later, but there are times when they wait until the end. So don't think there are times when clients wait until the end. The third pattern of behavior, and this one, this is a classic as per law society rules anyways. This is one of the main rules through which you're allowed to fire a client, actually, so it's a really big deal in practice outside of my personal experiences. But this is the client that starts, the technical term for it is the client that begins to cause a breakdown in solicitor-client relationship, solicitor being another word for lawyer. So the third pattern of behavior we're talking about here is the client that's not listening to your legal advice. And this isn't a judgmental, holier than thou, how dare you not listen to me. That's not what this is. This is when I am provided with the ask at hand, I start working really, really hard on thinking of creative solutions for you. That's one of the things that sets me apart. I'm not giving you the cookie cutter, which you'll see on Google. Almost every time a client comes my way, I walk them toward a creative solution that they haven't heard of before. That's my value add. It's my brain. And when you retain, I love what I do and I take it really seriously. So I sell you little bits of my brain time. And when I then give you that advice that is absolutely in your best interest, because why would it not be? That's my job. And you start acting other ways, there's a difference between the anxious client that does that. There's a difference between the tormented client that does that. There are different reasons owing to which clients will do this. But if they continue to do it at some point, it is a choice. and you're paying me for nothing, which actually isn't a good feeling at all. It's completely unsatisfactory. If I wanted to get paid for nothing, there's arguably a few different professions that I've chosen. But you're paying me for nothing, and I'm taking your matter so seriously. Sometimes client matters impact me outside of work hours as well, because I'm just thinking all the time how to get the best solution for you. And then you turn around and you say, no, thank you. Well, I wish I'd known that, because I could have given my time to a more deserving client, or maybe a more deserving personal matter of my own. I have other businesses, I have other priorities, I have other matters that I tend to. So that kind of client, for what it's worth, to close the loop on that one, so breakdown in the client-solicitor relationship is a reason actually that you can fire a client. It's a really big deal in the eyes of the Law Society. So there are protections toward lawyers that begin to experience that. But you should know, a lawyer-client relationship is not a best friend relationship. You're allowed to not do what your best friend says. You're allowed to go a different direction, this and that. But when you are retaining somebody so that they specifically give you advice on what to do, you wrote your own script there. I hope this video has been insightful. Again, this is not to scare you into being obedient sheep. That's not what we're talking about. I encourage creative thinking. I encourage, good value and negotiating and things like that. But this video is educational, as every other video on our channel is. It's something I've mentioned before, I think, how to know you're dealing with a good lawyer, how to get the best out or the most out of your lawyer. And I was thinking, I haven't done a video on the kinds of clients necessarily. So I hope this video has been helpful to you. If it has, give this video a big thumbs up. Let us know in the comments down below if you've ever come close to any of these behaviors yourself, or if you've had a friend or a colleague that's gone through something similar and they've gotten into, a difficult follow-up situation because of it. Otherwise, our website is graphenebusinesslaw.ca. Our email is info@graphenebusinesslaw.ca. And of course, I thank you for watching.